handouts I think was helpful that you might want to check out later on is this handout by Bob Keebler. Bob Keebler is a pretty famous CPA in Wisconsin, and he's had a lot of involvement in the development of IRA trusts or retirement plan trusts. So I strongly recommend you take a look at that. And also there's an article that I wrote for the North County Bar Magazine. So this came out in April, and I just included a copy of that as well. So this is kind of like a synopsis of what we're going to talk about today. It's just a little bit more abbreviated. And then the last thing I wanted to mention is I've got a new book that I published a few months ago, and it's on this very topic. Anybody who wants a copy of it, we're happy to send you a copy. Just give me or one of my team members your card and just put RPT Trust. We call them Retirement Plan Trust, Retirement Protector Trust. So if you write RPT on it, we'll know that to send you a book. So with that being said, let's get started. So some of the objectives today are a broad discussion of the stretch out that's available to beneficiaries of your IRA, 401k, other qualified retirement plans. And a lot of people don't realize that this stretch ability is there. Can everybody hear me okay? Okay, let me know if I'm not talking loudly enough. I'm not as dynamic in projecting as Dave, so. And also, we have concerns about creditor protection, asset protection of these IRAs when they move on to the next generation. So if we're leaving them to children or to grandchildren, a lot of people don't realize there is no creditor protection or shield for those assets in the same respect that they would be for the original owner. So we're going to talk a little bit about that too. And we'll talk about the U.S. Supreme Court case that many of you may already know about, which is the Clark case that was decided by the U.S. Supreme Court last June. So we'll talk a little bit more about that and its ramifications. And then finally, we'll talk about the factors to consider when deciding who should be the primary and who should be the contingent beneficiary of your retirement accounts. So this is not a foundational discussion. This is a discussion that's a little bit more about elevated. So I'm assuming that most of the people in the room have some more basic understanding of estate planning and that you'll understand what I'm talking about. But please don't hesitate to stop me if anything gets confusing, or if you want to talk to me offline or after, I'm more than happy to explain, because this is a little bit more advanced planning. So some other additional resources are Natalie Choate's book, Life and Death Planning for Retirement Benefits, and you can find this and order it at ataxplan.com. This is like the Bible when it comes to retirement planning. So I definitely recommend that you get that. And then also, many of you might know who Ed Slott is. He's a famous CPA, and you can get valuable information about IRAs at irahelp.com. I'm going to have some more resources at the end for you as well. So why do you need to have a foundational understanding about this type of planning? Well, more than $18 trillion of accumulated wealth is held in IRAs, 401ks, and other qualified plans. And for a large number of clients, this may be the largest asset that's held in their estate. I have many clients that have, somewhere in the neighborhood of $1 million to $3 million in retirement fund assets, and maybe they own a home and they've got a brokerage account. But when you look at their total estate, their retirement accounts represent their largest asset. So we can't just treat these assets as we do their others, because the rules are different for these types of assets. IRAs were designed to accumulate wealth for retirement and not to accumulate for future generations. And the tax laws are set up that way. So you just have to do careful planning. So an interesting statistic here is we look at the power of deferral. And you remember how I said a beneficiary can stretch? So if we look at a dollar doubled every 20 years, tax-free, so we're assuming it's in an IRA or 401k and it's not being taxed, in 20 years, that amounts to over $1 million. If we take that same dollar and double it over 20 years at a 29% tax rate, like in a brokerage account, non-retirement account, that's only $45,000. So it's really a powerful thing. So this kind of represents what that looks graphically, assuming, I don't know, this slide's old. I didn't generate that slide. I think this one's from like 2007, so that slide should probably be amended. So the power of the IRA is tax deferral. And the longer you stay on the blue line, the more power there is to the IRA. And staying on the blue line after the death of the original participant is a tricky endeavor. So the focus of today's presentation is how can we maximize this for the beneficiaries and how can we protect them from creditors? So how do we resolve this conflict? IRAs are designed to accumulate wealth for retirement, not to accumulate for future generations. And trying to use the asset designed for more than one purpose for which it was not intended is what we'll be discussing. But we do have an out. There is the inherited IRA. So in 2003, we had some change in the law, and an IRA is treated as inherited if the individual for whose benefit the IRA is maintained acquired the IRA on account of death of the original owner. And under the IRS code and regulations, the IRA assets can be withdrawn based upon the life expectancy of the beneficiary. These are Treasury regs, and this is under 401A9 that were issued in 2003. So IRAs payable directly to a beneficiary are what we call an inherited IRA. And IRAs paid to a trust are also an inherited IRA if a few things are met. So some of those things are all the beneficiaries are individuals, can't have charities. The oldest beneficiary can be identified in the trust, and the required minimum distribution is calculated based on the life expectancy of that oldest beneficiary. But if just the trust is listed on the beneficiary form. So we have a certain way that I'll be talking about later where we can actually stretch through a trust based on each and every beneficiary's date of birth. So we basically have three main options for naming a beneficiary of an IRA for the stretch. The first is to name the beneficiary directly on the beneficiary form and hope that they stretch. The second is to list a qualified revocable trust that has the right provisions so that the trustee can stretch. And the third is a standalone retirement plan trust. Sometimes they're called IRA trusts, retirement plan trusts. In my office, we call them retirement protector trusts. So let's talk about option number one first. So the advantages of naming a beneficiary directly on the form, if it's a single person, this is where they might list their kids. If they're married, they're probably going to list their spouse first and then their children as the contingent. In doing that directly on the form, the advantages are it's got a simplicity factor to it, and it's also really cost efficient because there isn't any additional planning that they need to do. Disadvantages, the beneficiary may blow that stretch out. The custodian may not tell the beneficiary about the stretch out opportunity, and there's a lack of creditor protection from divorcing spouses, lawsuits, bankruptcy, and creditors. And there's something else I didn't put on here, which is contingency planning. So if you've got a child on as your contingent beneficiary, if it doesn't say per stirpes, for instance, it might just end there, and you might end up with a probate asset. So option number two, naming the revocable trust as the beneficiary. So an advantage to this would be if you have proper provisions for stretch out drafted into the trust document, the trustee can stretch based on the oldest beneficiary's life expectancy. It's good for parents with minor children who do not have large retirement accounts yet, if the children are the only beneficiaries, and this will prevent court action. So some disadvantages, we're limited to what we call conduit trust language. We can't do what we call accumulation style planning, which I'm going to get into in a later slide. But conduit just simply for this purpose means to go through the trust, the required minimum distribution funnels into the trust and goes directly out to the beneficiary. It cannot be accumulated inside the trust by the trustee. So then if it goes out to the beneficiary, remember Dave was talking about beneficiary controlled trusts and dynasty trusts, we can't hold it inside the trust. It's got to go out to the beneficiary where a creditor can attach. The beneficiary could also blow the RMD. So if you've got situations where you've got a spendthrift or somebody with a drug or alcohol problem or somebody who's immature, that could be a problem. And it's not a great asset protection device for larger retirement accounts, because the larger the retirement account, the larger the RMD is going to be that's coming out of the trust. So option number 3, which is what we call a standalone retirement trust, or I call them retirement protector trusts, IRA trusts. The advantage is that it protects that beneficiary from creditors, predators, from divorcing spouses, lawsuits, and bankruptcy. And it protects the principal of the retirement account that can be drafted to protect not only the RMD, but it can also be drafted with a second look opportunity. There's a private letter ruling that we'll talk about in a few slides. So more advantages. As I alluded to earlier, under these 2 PLRs, we can draft the trust so that each beneficiary can stretch their own through their own life expectancy with special language that we put on the beneficiary designation form. In our office, when we fill that out, we don't let the clients fill it out because it is kind of technical. We will split, if they're listing the kids as their contingents behind their spouse, we'll list them out directly as each child's life expectancy. So if we have 2 children, 50% to John Doe of the, whatever the name of the trust is, for their benefit. So something to that effect. So this allows a stretch, and it's more poignant if we have somebody that's young and somebody older, and in some cases we will have a 10-year swing between beneficiaries, so it could make a really big difference in how much they get. And it can be drafted to be also what we call beneficiary controlled. Dave mentioned earlier that we can have trusts where we give the beneficiary the opportunity to be in control, either as sole trustee or as a co-trustee with an independent trustee. There's a couple of ways to get to that end result. And as Dave mentioned, probably the safest way is to have them serve as a co-trustee with somebody who's independent. You could also draft it so that your child can act as their own sole trustee, but we always put language in our documents that allow them to appoint a co-trustee with them. So there's a couple of different ways to get to the same end result. And if we really wanted to have, more top-line protection, we could have that child resign entirely as a trustee and just have an independent trustee in place. So it's a great protection also for special needs type beneficiaries to prevent loss of public benefits. So one of the cases that I worked on recently was a husband and wife in their 50s, and they had $900,000 in IRA funds, and they wanted to set this up for their son who's got some mental illness issues. They're trying to get him qualified for public benefits, but their complete fear is that, oh my gosh, if we die, we don't want him on the street. We don't want him owning any assets because he would just probably do inappropriate things with those assets. But we don't ever want him to be on the street. We want him to be taken care of. And when they found out what that stretch looked like through a calculator that I was using, which I now have developed on my own on my website. So if you go to my homepage and you click the RMD calculator on the top toolbar, you can actually run a calculation where you have actually more than one beneficiary. But if you just had one, you drop down the box. But when I showed him this calculator and I showed him what that stretch looked like on $900,000, I should have brought the amount, but it was like something like $7 or $8 million or something. It was a lot because their son is only 24. So he's got a huge life expectancy. So, and that was assuming they lived to 85. So it was still a huge number. But the way that we draft these trusts can prevent a special needs trust beneficiary from not being entitled to public benefits, to medical benefits, and also not being in control of money that they might mismanage. So some disadvantages to the option number 3, which is to list the standalone retirement plan trust, are that it's more complex estate planning. This is a trust on top of a trust. It's got its own set of tax regulations, and it's just more complex. The need to ensure beneficiary forms stay current are coordinated with new accounts and new custodians. So think of the client who maybe has a large 401k or pension plan or some other kind of account, and then they roll it into an IRA. or they change custodians, now we've got new forms to fill out. So you really have to be on top of making sure that those get updated, which if anybody in the room here, we all deal with clients for the most part, you always got to be checking in with them to make sure you're finding out what changes need to occur. In our office, we typically see clients every 1 to 3 years. If they're on our client care program, we see them every year. If we haven't seen them in 3 years, we're calling them up saying, hey, we need you to come in. This is one of the reasons why. We need to make sure that their beneficiary forms are coordinated properly with their estate plan. And then there's an added cost to set up the separate trust specific for their IRA and 401k or other types of accounts, 403bs. So, it is an added cost to do that.
To schedule your meeting to discuss protecting your IRAs or other retirement accounts for your children and ensure these accounts get stretched out instead of cashed in, contact us now at 760-448-2220 or info@geigerlawoffice.net.